This could be your kid, and it could be a man serving more time for having the guns than for murdering your child with them.
Mr. Studebaker, now's the time scheduled for preliminary hearing. We have two matters that are scheduled. One that is specific. Go ahead. Thank you, Your Honor. We do have a resolution on these matters as follows. The waiver of preliminary hearing on this court's policy about written preliminary hearings or waivers is included in the plea agreement. On case ending in 0110, Mr. Brenner would plead guilty to count 1 murder as a second-degree felony. As part of the plea agreement on that case, count 2 would be dismissed. In case ending in 171, the state agreed to dismiss count 3, and we'll go over that plea in a second. The state agreed also to dismiss case ending in 128 in its entirety. Mr. Brenner, like we said, will plead guilty as to the amended charge. In case ending in 171, he would plead guilty to counts 1 and 2 as charged in the amended information that was filed on March of 2024. These cases run by agreement consecutively, resulting in an aggregate prison sentence of 3 to 30 years. There's also an agreement that in the case ending, or that this will be a mandatory imprisonment situation. There were some issues and information related to the disclosure of Dylan Rounds' body. That has been complied with. I don't think there's a dispute about that on that situation, but it is part of the plea agreement. And I realized that there was a Rule 11 conference as part of this agreement to follow through on that. Mr. Brenner has read through the plea agreement multiple times with Mr. Nish, has had all his questions answered, and I believe, yes, Mr. Brenner has actually signed that on March 29th, 2024. On case ending in 171, Mr. Brenner would plead guilty to count 1, possession of a firearm by a restricted person as a second-degree felony, and count 2, the same type of offenses. The same plea agreement is outlined as part of that, the same obligations, and this court again has had a Rule 11 conference as part of this. I believe, based procedurally, knowing that Mr. Rounds' family, Dylan's family, has a right to participate in this, I believe they have also agreed to this plea agreement as part of a global resolution on this matter. With that, Your Honor, when the court is willing, my client is prepared to enter the appropriate pleas and is prepared to sign, or has already signed the plea agreement, so he's prepared to actually submit them to the court right now.
I think there might have been just one, maybe I missed it, Mike, but I think that there was one provision that was missed, which is that the party stipulated defendant will not receive credit for any time served on any case, whether state or federal, other than time served in the 2 cases he's pleading to. But just to be clear, I believe that that's only about 17 days-ish. So
that is correct. What Mr. Wardle said is part of the plea agreement.
All right, thank you. Mr. Brenner, as your attorney explained with Mr. Wardle's clarification, is that your agreement in this case?
Yes.
All right, Mr. Wardle, that is the state's agreement, is that right?
yes, Your Honor.
All right, let me talk to you, Mr. Brenner, about these 2 documents. They're entitled the same, 2 different cases. You understand that?
Yes, sir.
Statement of defendant in support of plea and certificate of counsel. Did you read those documents?
Yes.
Do you have any questions about them?
No, sir.
Do you feel that you understand them?
Yes, sir.
Do you understand that they contain the constitutional rights that you have that you are giving up by entering your guilty pleas?
Yes, sir.
Do you read and write and understand the English language?
Yes, sir.
What grade did you complete last in school?
8th.
Are you under the influence of any drugs or alcohol?
No.
Are you receiving any mental health treatment at this time?
No.
Are you satisfied with your attorney's help and advice in this case, in these cases?
Yes, sir.
Do you have any other questions or need any additional time before I ask you for your pleas?
No, sir.
Are you doing this because this is what you choose to do?
Yes, sir.
Is anyone forcing you to do this?
No, sir.
All right, from the state, please, each case a factual basis.
Your Honor, in case ending 2311001110. 19-year-old Dylan Rounds was reported as a missing person on May 31st, 2022. Sheriff's deputies, along with search and rescue crews, made efforts to locate Dylan, but were unsuccessful. During the search, deputies discovered a pair of boots belonging to Dylan nearby. One boot had a blood stain that DNA analysis confirmed to be Dylan's blood. Dylan's phone records were also obtained, which showed movements on the day of his disappearance on a remote property in Lucin, where defendant was living. Phone data showed that the last signal from Dylan's phone was at the Lucin pond, and a search of the pond led to the discovery of the phone. A digital forensic download of the phone was conducted and led to the discovery of a time-lapse video taken at the time of the victim's disappearance, showing defendant with bloodstains on his arms and shirt as he is cleaning a gun. That was taken on the day when Dylan went missing. Dylan's remains were eventually recovered pursuant to the plea agreement in this case in the Lucin area, and forensic analysis revealed bullet holes to Dylan's skull, which was the result of defendant shooting him in the head. And then on case ending...
Your Honor, just for clarification of the record, the last couple sentences of that do not appear in the factual basis I believe the court has in front of us. We were using the document prior to the defense would stipulate to those facts, but they don't appear on the document in front of the court.
Yeah,
All right.
That's true. Thank you.
And Mr. Ward, before you continue with the next case, Mr. Brenner, with your attorney's clarification as well, is that what happened in this case?
Yes, sir.
All right, I'll find that those facts do support a plea of guilty, also that you understand the nature and the elements of the offense and the relationship between the facts to the elements in this case. Mr. Wardle.
Case ending 22110071. While interviewing potential witnesses regarding the missing person in this case, in the other case, deputies learned that a defendant had asked one of the witnesses to hold 3 black powder guns for him because he was a felon and he didn't want police taking them if they searched his property. The witness turned the 3 guns over to the deputies. A search of defendant's trailer led to the discovery of ammunition, powder, and caps that matched the caliber of the 3 guns. Defendant has numerous felony convictions, which includes at least 1 violent felony for malicious injury out of Maryland, which would be the equivalent of aggravated assault or felony discharge of a firearm in Utah. That made him a Category 1 restricted person.
Mr. Brenner, is that what happened in this case?
Yes.
All right, I'll find that those facts do support pleas of guilty, also that you understand the nature and the elements of the offenses and the relationship between the facts to the elements of the offenses. On each of these documents, there is a place for your signature, case ending in 110 and case ending in 171. Is that in fact your signature on the line where it says defendant?
Yes.
All right. The attorneys have signed these, both counsel, and I will sign them. I'm relying on them as part of the plea discussion that you and I are having. Case 2211000171, count 1. That is according to the amended information filed March 19th, correct, Mr. Wardle?
What's that? Sorry.
Count 1 is the amended information.
The amended information filed March 19th of this year, is that right?
Yes.
Count 1, purchase, transfer, possession, or use of a firearm by a restricted person as a second-degree felony. To that charge, how do you plead?
Guilty.
Count 2, purchase, transfer, possession, or use of a firearm by a restricted person, a second-degree felony. To that charge, how do you plead?
Guilty.
Case 2311001110. Mr. Wardle, do I have an amended information in this case?
No, I was just talking to Mr. Nish. I'll get that filed right after.
All right, Mr. Nish,
Yep.
proceeding without that on file. All right. Mr. Brenner, in that case, as to count 1 murder, a second-degree felony. To that charge, how do you plead?
Guilty.
I'll accept that those guilty pleas, I'll find they have been knowingly and voluntarily entered into. I'll dismiss any remaining counts that in pursuit of the agreement of the parties. Likewise, I'll dismiss case 2111000129 as part of the agreement. Mr. Brenner, you have the right to be sentenced in not less than 2 and no more than 45 days. I will have adult probation and parole prepare a pre-sentence report in each of these cases.
Judge, we waived the 45 before Your Honor came out. We were discussing dates. I believe that the 45 would fall on the holiday, and then the following week I'm actually out of town. We're asking the court well, is Your Honor wanting to special set this? There's going to be many victims, family members, I'm assuming, who would like to speak, or do we want to set it at the end of a regular law in motion?
Mr. Wardle, any input?
I think it would be, well, so here's the thing. If you want to put it on a regular law in motion day in the afternoon, I think it would have to be the only thing.
Correct.
So if you don't want to do that, then I think we would need to maybe special set it.
Okay. What date were you looking at then, Mr. Studebaker?
Well, it depends on Your Honor. Are we special setting, or are we putting it at the end of a law in motion?
We can do that if there's a time
If we could do July 1st,
at 2:30?
sure. I know that they're getting some feedback right now from the family members, but I don't know how long it's going to take. So I was thinking, we spoke with your judicial assistant before court. She said right now that day is pretty light. I would propose we put it at the normal 1:30 and then just resolve the case and have sentencing once anything that's already on the 1:30 calendar is resolved.
All right, Mr. Wardle, 1:30.
That would work.
All right, let's do that. Let's set it for July 1st at 1:30 for sentencing. That'll be an in-person hearing, and so all matters will be handled in person.
Just real quick, I think, unless I misheard you, on the case that's being dismissed, I think you might have said the wrong number. It's 211100128. Just to make sure. Is that what you have?
Same thing.
If I misspoke, it is 211100128. Is that right?
Yeah, that's correct.
Yeah, if I misspoke, that is the case number that is dismissed per agreement. Mr. Brenner, you have the right to be sentenced within 45 days. If we go to July 1st, that is beyond 45 days. Are you willing to waive your time to be sentenced within 45 days?
Yes, sir.
All right. Mr. Studebaker, Mr. Nish, you previously agreed to that. We'll set this then for July 1st at 1:30 for sentencing, and I will have adult probation and parole, as I said, prepare that pre-sentence report.
Thank you, Your Honor. Sam, you may want to block out the rest of that.
Counsel, are there any other matters that need to be addressed today?
I don't believe so.
No, Your Honor.
All right. Thank you. We'll see you on July 1st at 1:30.
Thanks, John.
Court will be in recess.
We're in recess. Good to see you, Judge.
We wanted to set in a different way. It's really disappointing that our court systems did not make him say guilty to murdering Dylan Rounds. More than likely, Brenner will die in prison. But it shouldn't even be an option. It should be a 25 to life. It should be an aggravated murder. And we weren't first. We were part of it. But the justice system forced us into this type of plea. And only 1 to 15 is for murdering Dylan. The rest is gun charges. Constituents of Utah, think about it. These laws are made by our legislation, and if you want them changed, this could be your kid, and it could be a man serving more time for having the guns than for murdering your child with them. The laws need to change.